Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? We are fresh off the golf tournament, and I have gotten news. The jury is out with this Trevor Summers case. I am actually just getting home, and I'm trying to set up my Bluetooth headphones here so that I can watch this closing argument of Trevor Summers that he does on his own. It's about 30 minutes. I listened to the state's first and second close because I wanted to be able to kind of see what their arguments were, what their responses were to Trevor Summers. I have not listened to his yet. So we are going to listen to that together, which is going to be a lot of fun. Let me know what questions you have in the comments section. I will try to get to as many of them as I can. And what's kind of interesting about what's happening in the timing of all of this is by the time we're done with this, theoretically, there should be a verdict. And that to me would be cool if we got a verdict by the end of this video that we could, let's see if that worked. No, it did not. So hopefully we can get a verdict by the end of this video. That would be cool because then we can react to the verdict together. This is kind of annoying. I don't know why they're not automatically connecting like they usually do. There we go. All right, how's everyone's Friday going, huh? Going good? Good. Looks like we're connected here. All right. We are up and ready to go. Everything's working. Sorry for the technical difficulty there in the beginning. It did not automatically connect like it usually does. All right, let's do it. Let's see how Trevor Summers does representing himself.
Good afternoon, gentlemen. Good morning, Good morning, Steve. I'd like to just be able to share with you
Sound good?
a re-representation of what we've heard over the last week. And I'd like to start with just helping you understand from the details that were given and consider that the condition of both myself and Mrs. Mathewson were not adequate enough to truly paint a picture that you could understand. If you recall, we spent a lot of time that weekend just talking, just trying to figure things out, wrestling around, fighting about a variety of issues. Some of them you heard about, some of them you haven't. But you do remember that we didn't sleep very much. Our emotions were all over the place. Our stress was high. You've heard these things through her testimony and through statements of others in this case. And so I ask you to please keep that in mind as you look through, as I walk you through the facts that were presented. I first ask you to pay attention to the photographs. As you walk through the photographs, I ask you to please look through them and notice things in the residence of Mrs. Mathewson. That there were no signs of a struggle. That there was not broken glass or dents in walls. There's not scratches on countertops or blood splatter. This was not a scene that depicted some kind of crime or some kind of anything more than what she described as wrestling around. And I also ask you to look and see that the things aren't thrown about as she described. Things are where they're supposed to be. You can see that we packed, we left, and we had a plan to go to my house. Her accusation is that She was tied to go to my house. But I asked you, does it make sense to go meet children with a woman tied up? I also ask you to look at the items that were disturbed by law enforcement during their 3 times investigating that home. There are a number of things, statements that were made, including a variety of articles within the home that weren't brought in front of you, so that you can't make conclusions, so that you can't corroborate the stories or the statements that were made here. I also ask you to look through the pictures of the vehicle. I ask you to consider that they don't line up with her story as either. Little things like the pancake platter sitting in the second row and not the third. Little things like a purse being full of all kinds of contents that were helpful to her, useful to her, that she didn't really need if the whole intent to take her somewhere and kidnap her or steal her car. Why would she need her purse? Why would she need her phone? Why would she need her charger? It doesn't make any sense. And I also ask you.
So I will just say that little things, and keep saying little things over and over again, is actually a common strategy with lawyers, saying like all the little things build up to a big thing. Also, sometimes people think though that backfires, especially when you call them little things, because then maybe the jury won't think they're significant. So just as far as like, he's not a lawyer, so that's part of the way I'm looking at this is you grade on a different scale when you see a non-lawyer do a closing argument versus an actual trained lawyer who's done this before. So I will say there's a different scale, but that's an argument some lawyers do use. It can backfire. What would you think if you were a juror and someone and a lawyer was explaining something, say all these little things they build up? Would you say, well, they're little, so they're not that big of a deal, it doesn't matter? Or would you say that makes sense because a lot of little things may create reasonable doubt? Not just in this case, I mean, generally speaking.
Ask you to look at the car handle. The car handle's far up in the front of the door. And her statement is her hands are tied behind her back.
Thank you, Rita.
Most of us understand that if you lean your back against the car door and you pull the handle, you're going to fall out. You're going to tumble on your head. But she didn't say that happened. I also ask you to look at the pictures of Mrs. Mathewson. You'll see the full pictures when she was evaluated and examined after these events. You'll see that the bruises line up with wrestling around. You'll also see marks, bruises on her arms where she said, I lifted her up through a ravine. And you'll see exactly that's true. We pulled her up through a ravine. You'll see that there are blisters on her heels. Again, I mentioned to you guys, or I questioned her about why she didn't put flip-flops on.
Yeah, he didn't mention anything to them because he did not testify, which is totally fine, but he's got to be careful in his arguments. He can make arguments. He can make arguments that it doesn't make sense that, you know, why would she say that if she said I did this? But he can't say, while we were there, I said this or I did that if it didn't in fact come out. Just like he said, I said to you guys, he's not allowed to say to them what he thinks happened or what his version of the events are. So he's got to be really careful there because he didn't testify. You can't use this as your opportunity to testify.
Why she would put shoes back on if she already had marks on her heels. And her answer is non-responsive. And so...
Objection, Judge. Inappropriate misstatement of the facts.
Hold on. Well, I'll instruct the jury at this time that what Mr. Summers says.
Rely on your own memory is what he's going to say to the jury. Thank you, Tanya. So he said her answer was non-responsive. They object because they think she did respond in an appropriate way. Sometimes what I'll do, which, you know, it's maybe borderline inappropriate, is I'll say, objection, Judge, that's not what she said. But sometimes that's a speaking objection. So the more appropriate objection is misrepresentation of the facts, like this prosecutor did object. But the judge is always going to say, rely on your own memory if the two lawyers, or in this case, the pro se defendant and the lawyer, are not agreeing on how the facts came out through the case.
Says during closing and the attorneys during their closing is not evidence in the case. I will instruct you to rely on your own recollection of what the testimony and evidence was.
Gentlemen, if you remember, we walked through those fields for hours in muddy conditions. Those shoes, as Ms. Mathewson testified, were getting stuck in the mud, and clearly that's what caused the blisters on her heels. You won't see any kind of rope burns on her wrists or her ankles. They're not there. You also won't find any photographs of anything after that. The law enforcement failed to investigate anything further beyond Miss Mathewson's condition to see if another bruise would show up on the other side of her neck, or if any bruises or marks would show up anywhere else. That would have probably been a normal thing to do. And you'll also see that we physically fought each other. I don't argue that with you. And I also ask you to look at the photos of Mr. Summers, of myself.
He's referenced himself in third person a couple times, which is always a bold move. So if you broke a TRO, tricked your daughter to get you in the house, and you're admitting that you guys fought each other, and your wife is saying she wanted you to leave, I don't think that's a good concession, personally. Because he's admitting that they fight, I think that's a bad sign for him, and I don't think that's something that's really going to create reasonable doubt as to, what all happened here. Future, does representing yourself increase chance of appeal? Not necessarily. In my opinion, it shouldn't, because judges don't usually let a person take that decision lightly, but I wonder if that is part of a strategy in doing so. So it cannot be the reason for appeal that you represent yourself, like ineffective assistance of counsel. But the only reason I would say it adds potential appellate issues is how the prosecutor acts. And I do think the prosecutor and the judge steamrolled him a few times. I can understand why they get not excited, but they want to make sure they get him convicted. And I understand everybody watching seems like they want him to get convicted. I understand all that. But his fundamental rights, asking improper questions, knowing that he's not going to be able to object and allowing that evidence in, that's where sometimes the appellate issues can go up, as well as saying that Mr. Masterson said something or misrepresenting that he said something. That's almost always an appellate issue. When a defendant testifies or it represents himself, that's not necessarily there if he doesn't represent himself. So no, they take care of all that ineffective assistance of counsel stuff, but the prosecutor and the judge have to be on their game to make sure they don't add any appellate issues when a defendant represents himself. Kathleen R. Shoes, flip-flop Summers did ask the victim why she wore shoes during the cross-examination. I agree. He did ask her. And I don't think she said, she definitely was very clear that that the ties gave her blisters, but I don't think she gave a lot of great answers as to why she put the shoes back on, if she had the blisters, when the blisters started, things like that. Anna Marie Mitchell, thank you for the super sticker. Yeah, Ashley said she sat on a jury where the pro se defendant referred himself in the third person. It's very weird. I agree. It's very, very weird. Sherry's saying she didn't. I don't know what the ex-wife was a great witness. Tori, I think at times she was great. It's a miserable situation to be in. Miserable. At times she was great. At times I did not think she was a perfect witness. But I feel terrible for her if this did actually happen to her. I feel terrible. I feel terrible for the whole family and what's happening to them. He did not testify by choice, Joe. No. You can go pro se and testify, and you basically just sit on the stand and you give a narrative and you just tell your story. All right, let's get back to it.
You'll see that I was in no condition to be interviewed by the police. You'll also see that if you were in that position, you would feel vulnerable. Feel taken advantage.
Wow. Okay. So let me just tell you this. If you were in that position, you would feel vulnerable. And I will just say, I'm shocked the prosecutor did not object. I'm shocked. This is the way, when I was a prosecutor and I had a pro se defendant, the one thing I told him before closing is you cannot say, if you were me. You cannot put the jury in your shoes. That is the golden rule. He literally just violated it. He just violated the golden rule by saying, if you were me, I don't think you would have wanted them to do that in that vulnerable position for the cops to interview you. However, if he's not guilty, that's not going to be an appellate issue because he's pro se and violated the golden rule, especially if the prosecutor doesn't object. So, but it's very interesting.
Advantage of. You see that I was restricted, I was captive, and possibly coerced. And I argued that. Aside from the pictures, gentlemen, I ask you to look at the videos. If you look at me at Miss Summers' house, I'm in a confused state of mind. We're going through a divorce. We don't know what's going on. I question Miss Mathewson.
All of you guys are telling me it's coming. That's funny. Well, I would have jumped on it right there and nipped it in the bud the first time you mentioned it. I think she's reading something, and sometimes people struggle to read and listen at the same time. But Yeah, I would have jumped on it right there. That's funny. It's coming later. You all have already seen this.
About our conversations about her pregnancy. And she recalled some things that we had talked about. This was something that I want you to consider. I also want you to consider a very special moment in that video where I'm asking Ms. Mathewson what else she would like me to say. I submit to you guys that when you're in these kind of positions, you can clearly see through the complexity of this evidence and through the variety of it, how the emotions are all over the place. I also asked you to look at the Walgreens
Mark, that's a good question, and I'll answer it in a few minutes.
videos. Mrs. Summers goes into, or Mr. Summers, myself. I go into the store, but that's the opposite of the state's witness. He doesn't see me go into the store. He doesn't even know where I came from. That's his testimony to you guys. He doesn't know what kind of clothes I'm wearing. He doesn't know what kind of clothes she's wearing. But this is the main witness that's supposed to identify that the one single thing that he saw was her hands behind her back. He said her hands behind her back. I don't know how she ran out of the car, but were they tied? You have to make this decision. Again, I point to you, how do you get out of the car, your hands tied behind your back, and open a door and not fall out? I also asked you to look at that Walgreens video and see that it was parked right in front of the store. If someone's held captive in the car, I don't think it's logical that you would park right in front of the store. I think you would park somewhere where no one else might see that. I think you would probably park in a different way so that if you needed to, you could get out quickly. But the testimony was that the vehicle was pulled directly in front of the store, head first into the parking spot. I also ask you to consider.
I definitely think that he has made a good point of there was not this like master plan that he was executing here, kidnapping her and taking her somewhere specifically. I don't think that was the case. I think that he kind of snapped and did all this stuff, and it was kind of like making one decision after the next. I don't think he, planned where he was going to park all the time. I think he was taking it step by step. I think at certain points he thought that she was good with it because she was trying to play along. But to me, this is tough because the overarching theme and even the facts he agrees to me, I think make it really tough for him to win outright.
Looking at the vehicle not speeding away. There was no rush to leave there. It wasn't that much of a concern. It was a moment of panic. As you also look at the other videos, please look at the McDonald's video. Mrs. Mathewson is free to leave. It was a perfect opportunity. If this is true, if all this weekend, after 50 hours, all of these things were true, what better opportunity than there for her to leave? She had the opportunity to order what she wanted. She was not being held by myself at all. Now, I know the video played with a little bit of choppiness earlier. I ask you to watch it again and see if you can get it to play smoothly and see that, no, this is a agreed upon situation. We're in there together. We're getting breakfast. We're moving on. I also see that she is cooperative with me. She's using her purse. She has the contents of that purse.
Cooperative is not a good word to use when you're trying to make it seem like a consensual outing with your ex-wife that you're rekindling the flames with. Cooperative seems like you've kidnapped someone and they're doing what you told them to do. In my opinion, that's where language and words are really important and definitions are really important. Personally, he is saying, you guys, I noticed you picked that up. That's a little cringy for me, but for lay people and for people in these situations, it's very difficult. And then Brittany said, when do you guys think a verdict will come? I think that also you guys is a lot worse if it's not an all male jury. So at least he has that going for him. I think the verdict's going to come today. I think they're going to stay as late as they can, and the jury's going to come with a verdict tonight. And it could be by the time this video is over, which would be interesting. And if it's not out by the time this closing ends, I'm going to give you my prediction on what I think the verdict will be.
And there's no issue that whole time, almost 2 minutes, maybe even more, of going through that drive-through. Logically, I would not be able to get out of that vehicle. I had a seatbelt on, and my door would immediately hit the building. And again, a great opportunity for her to leave. As you look at the Sitco video, There are 3 videos on there. 2 of them show me inside the store. One is from a different angle where you can see that the vehicle is not parked at the first pump. I ask you to look at that. Ms. Mathewson states that I pulled as close to the store as possible and right next to the first pump. That's not true. I didn't have any concern about where I had to pull close in proximity to the store. You can see that from her vehicle where her gas tank is and where you have to pull into the gas station. It's just logic sense. You can also see that I was there inside the store for a number of minutes. And then again, another opportunity for her to just walk away, run away. I remind you guys that this is 6:50 in the morning on a Monday morning. There's people all over the place. It's rush hour.
Objection, Judge. Facts not in evidence.
That's what you've got to be ready to object to when he starts trying to testify in closing argument. But he did say it was rush hour. He did ask her if it was rush hour traffic, and she said, yes, it was Monday morning rush hour traffic. I kind of zoned out there. I'm not sure if that's what he was saying right here in his closing, but you have to be careful as a prosecutor when the defendant's pro se that he doesn't just get up there and testify to facts, not evidence. That's a great objection that you have to use whenever you're, listening to see if he is trying to now testify during closing argument, because he cannot do that because they don't get the right to cross-examine him if he's bringing out new facts now.
I will instruct the jury again that anything that Mr. Summers or the attorneys for the state say is not evidence, to rely on your own recollection as to what the evidence was in this case and testimony that came from the witness stand. I will instruct you, Mr. Summers, to avoid arguing things at this time that are not in evidence.
Okay. Gentlemen, just remind you that they showed the time on the receipt of the McDonald's slip, and that it was a Monday and it was just before 7 a.m. Also, then ask you to consider the testimonies of the people.
So somebody said, I'm watching from the UK. Is this guy a lawyer? Is that why he's representing himself? No, he's not a lawyer. We have a right to represent ourselves here. What's the saying? A man who represents himself has a fool for a client. Yes. So Barb M, I would agree, except that he had the kid spying on her and helping him get in the house. So I will say, I like to look at these things as objectively as possible, and I don't condone it at all. And I don't think people should do that. I definitely don't think they should use their kids in family law issues and battles. But I will say, this is a lot more common than you may think, where the kids want the parents to get back together, and the parent that does want to get back together, the kids help them and try to find a way to get them in the same room, and they're texting without the other parent knowing. So I don't think that we should condemn anybody or convict anybody, I should say, for a crime for that. Mark, sorry for my ignorance. Why is that the golden rule? Isn't that the reason you want the jury of your peers so they can relate to you? Yes, Mark, great point. But guess what? Legally speaking, you're not allowed to do it. I think you should be able to do it and say, if it were you, if this happened to you, how would you feel? But the way the laws are written, lawyers throughout time have felt like that's too difficult. It makes them sympathize or empathize or make decisions not based on the law and the facts and the evidence. And therefore, we cannot, as lawyers, say that to them. But we hope they're thinking it a lot, because our clients had to go through all this. And, it's really not fair to just say, well, insurance premiums may go up, therefore let's screw my client and make him pay for all of his own medical bills, even though this guy hit him, T-boning him through an intersection because he was texting on the phone. So, interesting point, Mark.
The first is Randall Crosby. Again, he does not recall where I came from. He doesn't not recall what clothes I was wearing, what clothes she was wearing. His statement is pretty inaccurate. He doesn't recall what vehicle it was that was 15 feet from him, even though the name and the insignia is right on the back of it. Only he was focused on was getting that license plate. He was paying attention to that, not what was happening with us. I don't understand how he could be able to look at the vehicle and get the license plate at the same time pay attention to what we're doing. He was also on the opposite side of the vehicle in orientation. He's standing by a red box machine. As you look through the videos, as you look at the overall of that story.
So this is great, Brooke. So he used the kids to break a restraining order against him and brought by the victim, and we should not use that against him. Okay. That's not at all what I said. I literally didn't say that. I said, let's just not convict him of these crimes because his kids were used to help them talk to each other. That's all I'm saying. That doesn't mean he did all these crimes just because he used the kids to talk to her. That's all I'm saying. If he would have gotten arrested for violating his restraining order, absolutely. convict him for that. But this is just great by taking it like 6 steps further than what I actually said. That's not what I said. We're talking about this stuff in pieces and parts because it has to be a whole story, not just one part that tells the whole story. That's all I was saying. Just trying to give some context.
Stuart, you'll see that his position was not a very good view of our position, of Mrs. Mathewson running away, of my position coming out after her. He did not chase us. He did not follow us. He was also the only person standing outside at that time. You'll see a few other people walk into the store a little bit later. All of these people were also available to Miss Mathewson to go and talk to. If I'm in the store, she could have went and talked to him or tried to seek help from him. He also, in his 911 call, you can listen to that, it says that he didn't even know the street location of where he was working. He didn't know that the place of his employment in his testimony, or what time he started the shift, what time he ended. He was also not close enough to hear the things that were being yelled at each other. Mrs. Mathewson said that she yelled. We were screaming at each other as we were going back to the car. But he couldn't hear that. I then point to you to Kimberly Shea, who gave you a very accurate evaluation of what she saw. Her statement was true. She was pulled in directly across from the passenger side of that vehicle. She saw the emotion on Mrs. Mathewson's face. She saw that we were in some kind of an argument, some kind of a torment. And she also saw Mrs. Mathewson's hand. She saw her hand leaning on the door sill and leaning up against her face. That wouldn't indicate that her hands were tied at all. I also point you to Ms. Shea's knowledge of the exact type of vehicle it was from the moment that she saw it, color, the position, how far she was exactly from the vehicle, and that we left. Then we go to David Chesla, Dr. Chesla. Dr. Chesla did not operate on me as he stated. He also doesn't remember even seeing me. He could not tell exactly what time and what type of medications were given to me. He's only assuming from some records that he may or may not have been involved with. He doesn't know what the volume of the doses were or what types of medications could have had. He didn't testify to what kind of impact those combinations of medicines could have had. He did not speak with law enforcement, and his responses were quite vague. Then to the other medical professionals that testified. Teresa Wagner, Rita Hall, and Francesca Owen. They were all involved in some kind of DNA analysis or some kind of evaluation of Mrs. Mathewson's injuries and the sexual battery kit. And again, that sexual battery kit, the test came back, no evidence of rape pointing to me, no DNA match to me. And this happened immediately after the alleged sexual encounters. This didn't happen after Miss Mathewson showered. Her allegation is that this happened on Sunday, and this test happened, and the rape test was given to her on Monday. They also tested the clothing from Mrs. Mathewson, and none of that tested positive for myself being in contact sexually with Miss Mathewson. The sheet from the bed tested positive for my DNA, which the analyst said could have been there that day or sometime prior to that. As you do know, from Miss Mathewson's testimony, we were in contact prior to the 11th of March. I also ask you to consider the testimonies given by law enforcement. They were not a witness to anything prior to a simple, peaceful arrest. I did not resist. I did not see, not have any testimony of me causing any problems or acting in any kind of irrational way with them when I was arrested. They did not attempt to investigate, despite all of this available DNA, fingerprint analysis, things that could have corroborated the story, maybe made it a lot more sense for you. But they did not attempt to test the pillows to say, yes, this is evidence of her accusation. They did not attempt to test the Christmas lights to see if there's any trace, as the fingerprint expert testified to this, to see if there's anything on the glass bulbs or any kind of skin, any kind of anything with these Christmas lights. They did not attempt to test all of those items in the vehicle. I asked Mr. Becker, could this have been tested? Could this have been tested? And it was their position that, yes, it could have been tested. And if you think about it, think about all the things. When you look through those pictures, look at all the things that were in those vehicles and line them up with Mr. Matthewson's testimony and see, would those things have some value? I believe you would find that to be true. I also believe that the contents in the trash can, the rope, they collected it, but it was not tested to see if there were any kind of skin or DNA evidence on that rope. That probably would have been a good thing to do. They did not check the NyQuil bottle, the other bottles.
Thanks, Vivian.
Broken wine glass. Look at all these things. They did not check to see if any of those produced any kind of evidence that would corroborate the allegations against me. So you have to ask yourself, is that reasonable? Is that fair? They also did not check anything about this statement that they collected from me in a hospital that was taken after, again, you know that high dosage of medication was given to me. They did not check to see if there were boat charters on any kind of schedule or any kind of thing that could have
It's a good point.
corroborated my story there. They did not check to see if I had offshore accounts. They did not check to see if any of these directions that I'm giving. If you listen to that interview, I'm talking about this road and that road. I don't know. Maybe you guys are familiar with the area. Maybe you know.
Objection, Judge.
I will instruct Mr. Trevor not to place the jury in your shoes or the shoes of any party. Don't make arguments like that where you to the jury.
Okay.
You can
Wow. That's really interesting. So she was correct in that objection. Although he wasn't, it sounded like he was saying, I don't know if you guys have experience with that, which is different than the golden rule technically, but the judge to explain in front of the jury, not to ask the jury to get in your shoes. To me, if I am a juror and you all correct me if I'm wrong or tell me what you think. Okay. Tell me what you think. But if somebody says, oh, sir, you can't tell the jury think about what it would be like if they were in your shoes. If I'm a juror, I'm thinking, well, what would it be like if I was in his shoes? You know, it's kind of like saying like, you can't eat the forbidden fruit. And then what happens? They eat the forbidden fruit. So I'm thinking if I'm a juror and the judge said, I would be upset if I was the prosecutor, if the judge said that in front of the jury. I would have had that instruction done. Like I said, I asked for the defendant in that other case to be instructed outside the presence of the jury not to do this. So being instructed in the jury, that when the jury's in front of you, for the jury to hear that instruction to me is not great. And the jury is now going to be thinking about that. In my opinion, that's what I would think, especially if you're not a lawyer. So that's interesting.
You can argue the facts, but avoid what you just did.
Gentlemen, I would just assert that the law enforcement did not check to see if these directions even fit to a map. And they also didn't seem to think that the statement about immigrants was a little bit out of whack. I encourage you to listen to that video or that audio of this interview and see if someone really does sound like they make sense, or if they sound like something different, in fear, in panic, concerned. Look at the condition that I'm in, look at the medication given, and please draw a conclusion from that. I also submit to you that law enforcement failed to recognize any red flags or false statements regarding if I owned a house and if I was able to just sign it over to somebody. If I owned a car and just able to sign it over to somebody. Or even if the passwords to the bank accounts were valid or not. These all would have been important for you to make a decision about whether or not I was giving correct information. The police,
Those are the arguments that are less convincing to me, where it's like they should have seen if there were offshore accounts or whatever. Melanie asked, does she say objection judge instead of your honor for a particular reason? Feel like your honor is more respectful. So there is no disrespect when you say judge or objection judge or judge, can we do this, or your honor or the court. They're all synonymous. It is not disrespectful. It's totally commonplace here in Tampa, the Tampa Bay area, which is where this trial is. So this judge specifically would not take any offense to that.
also purposely did not interview me when I was awake, sober, clear-headed, recovered. They only interviewed me one time at a hospital where I was vulnerable. That's it. There's no other time. They didn't come and ask me later if I could please explain things better to them. They didn't come with a written statement, ask me to sign it. They didn't try to.
What would be interesting is I wonder if he already got a lawyer and wouldn't talk to him anymore, but he's arguing like he would have talked to them. So that's an interesting indication. Again, that only comes when somebody represents themselves to say something like this, like the cops didn't give me another chance to explain. Usually once you get a lawyer, you don't want to explain anymore to the cops because now you're pleading the fifth. But interesting that he's making this argument.
Try to attempt to get any other information from me. They thought case closed. He said what he said, and that's it. I also submit to you that law enforcement made no attempt to follow up on the marks on either side of Mrs. Matheson's neck. Again, they took some basic statements and said, oh, you know, it's been a long weekend. We're just going to conclude here. Law enforcement also could have taken more items into evidence to fill the holes in the story and to corroborate this story. And I believe that would have been much more helpful for you to make a decision in this matter. Then we turn to the children. They only said a few things. I didn't ask them much. I didn't believe they even said too much of value, but the little bit that they did say, it contradicted their mother being dragged down a hall in the house. It contradicted what their mother said about being restrained in the corner of the living room. It also shows that mother had no interest in speaking to them when the oldest Arden came into the home, while the youngest two were into there. There was no information given to them. There was no concern to them about while Mrs. Matthews and I are arguing and fighting in the home. And then we turn to the statements of Mrs. Mathewson. These statements were outrageous. The statements were exaggerated. The statements were, most of them, impossible. The responses to simple questions were abrupt and over the top. The calm answers, if you recall, they revealed some truths, such as wrestling in the living room. That's a true statement.
So is he calling the ex-wife a liar at this point because she was aggressive with him on the stand? I think that's what he's trying to go. It's not a great look.
Such as sleeping in the car. That's true. Such as not caring about sex. That's true too. Such as just calling it sex. That's true. About being woken up by water droplets rather than some other crazy way. You guys remember the timeline that was presented. They say that I came to her house at 12:30 in the morning, and she finally woke up around 3. Text message showed between me and my children, and I'm trying to wake her up. Showed that I tried to turn on the television loud. I tried to put lights on and off. Tried to slam some doors. I think you guys can understand that. I also ask you to pay attention to the statements that Ms. Mathewson made. She drove to my neighborhood after these prior allegations. She said nothing to her children to help her in this alleged situation. She was already in the bedroom, and she made no statement of being drugged back into there. She claims an entire bundle of rope fit in my jeans pocket. That rope, again, was not tested to see if used in any allegations here. She claims that there was a sock in her mouth, but does not recall those details. And as you go through the evidence, you'll see that no sock was recovered. You'll see that no sock was tested to corroborate this claim. She claims that duct tape was on the mouth, but again, nothing corroborates this. You have a picture of duct tape. You have a very simple thing that law enforcement could have tested and said, yeah, what she said is true.
I'll pop and answer a couple questions here. He sounds like he did his research. He did an awesome job. Other people saying they think he did a good job. I think his demeanor has been good throughout the trial. He has not been rude. He's been very successful, and respectful. And I think he's made some good points and picked some good holes. But I think he's missing some legal arguments, and he's missing kind of the overarching point as to what makes him seem guilty with the totality of the circumstances. I do think he's missing some of that. But I don't think his presentation has been bad. Absolutely not. You all probably haven't seen a lot of pro se people try to represent themselves. He's doing better than some lawyers. I'll just tell you. I've seen some lawyers who just should not be doing trial work. Kian Wags, I'm late to the party, but became vested from your video yesterday. Number one, has he been this soft-spoken the entire trial? Yes, he has been calm, cool, collected, and soft-spoken. Why did the court let him go through so many lawyers? Well, private lawyers, you're allowed to fire and hire on your own. Public defenders, you're allowed to fire, and he ended up getting a court-appointed lawyer, which he fired. Then he said he was going to represent himself. The reason the court allows this is because they don't want to create an issue for appeal with ineffective assistance of counsel. So if the defendant tells the judge, tells the court, tells everybody this guy stinks or this gal stinks, they don't care about my case, they're not doing anything on it, they're not prepping for it, they're not ready for it, and they go to trial and they lose, well, that's setting up an ineffective assistance of counsel claim for appeal. Nobody wants that. So if he wants to represent himself, you let him represent himself. You try to let a person choose their lawyer to the best of your ability. So that's why he was able to do all of this.
Press that here. You also have a statement about predominantly calling it sex, and then has a cigarette after each time. She offers no details like in the other accusations. We just had sex and we move on. She also says that she was screaming when she came back to the vehicle at Walgreens. Again, no witness made this kind of observation. She says that she opened her car door with her back to it and did not tumble out on the ground. She says that she refuses to recall the majority of the time we were together over the weekend. If you recall, we were together roughly 30 hours apart in the country, in the woods. But she can't remember most of the conversations that we had. She also says that we are driving around on Monday morning between the hours of 6 a.m. and 10 a.m. on some very busy roads. But she made no effort to signal another car or really elaborate on any of that time for you. She also states that we argued throughout the weekend, and that should truly help you understanding the range of emotions that were happening, the things that were happening in a divorce situation.
Objection, Judge. Facts not in evidence.
And at this point, he's going to tell the jury to rely on their own memory of the testimony. But she's trying to say nobody ever testified to that. That's not a fact. So, I think that is, she's making her point, even though he's able to make his point as well. LOL, assuming from the records, that's why hospitals keep records. MSK, you'd be shocked how many medical testifiers and experts just look at the record and say, I have no independent recollection. I'm just relying on records. But we've also had medical providers literally say, yeah, you know what? My records aren't that reliable. So that's pretty terrible when they say that, but it happens.
Again, I'll instruct the jury to rely on their own recollection of the facts were. I'll caution Mr. Summers to please avoid arguing or referring to any facts that were not testified to in this case.
Yes, then we'll go to my interview. If you evaluate me on this statement made in the hospital, I hope you find that it doesn't make much sense. hope you find that there are a glaring number of issues, sometimes in, sometimes out. Things about, again, bolts and incongruent driving directions, about immigrants, about a variety of things that really show a concern for the situation I'm in. So please evaluate that based on the conditions that you know surround that interview. Aside from this, gentlemen, I just remind you that from the beginning, I've assumed my presumption of innocence, and I maintain this until now. I assert that the state has not proven what was in my heart, especially regarding 2 counts of
Objection, Judge. Inappropriate requirement of the state to prove what's in its heart.
I'll instruct the jury that what
No, that she's wrong. I don't know what the judge is going to say. She's wrong. He can absolutely say they did not prove what's in his heart. That's motive. They did not prove a motive. It's not an element. They don't necessarily have to prove motive, but that's absolutely an argument that you can make as a defendant or a criminal defense attorney that why would I do this? That's not what's in my heart. They didn't prove it. That's a totally proper argument, especially for a pro se defendant. And this is the type of stuff I'm talking about. Just sit down and try to object as little as possible if you are the state. Golden rule, absolutely, and facts not in evidence. Besides that, you shouldn't really object to anything else because you don't want to create an appellate issue. That's the point. Give the guy rope to hang himself with, but don't bring up appellate arguments.
what Mr. Summers say is certainly not the law. In this case, the law will come from me and the elements of the crimes will be contained in that law. Mr. Summers, restrict your argument to the law and the evidence in this case.
Yes. I'll rephrase that, gentlemen. The state has not proved my intentions. They have not proved that I intended in counts 1 and 2 to kill Mrs. Mattheson. In my statement in the hospital interview, I clearly never said I intended.
So Agni, really quick, it's interesting because the first draft of a closing argument is always kind of all over the place and confusing because you always have too much in there. You don't want to recap the whole trial. You want to hit the highlights. You want to give jurors something to hold on to. And when they go back and argue, they can say, yeah, but remember he pointed this out in closing. Remember this piece of evidence. You really want to give them the tools to argue if they believe your side. But it's really hard for a non-lawyer if you've never done this before. Even lawyers who have done this a lot, they start out with all these ideas and it's hard to kind of get them all to go together. You don't want to recap every fact and every witness, but you're kind of looking at somebody that's inexperienced. It is a little disorganized and kind of all over the place and hard to follow. And again, as a lawyer, I'm issue spotting. That's what they say in law school. We get points for spotting issues and pulling out issues. And I think he's bringing up a good issue here, a good issue there, a little hole there, maybe some reasonable out there. But as a whole, it's a little disorganized. I agree with you. And it's kind of hard to follow some of it.
To hurt her. If you're relying on that, that's fine. I never said I intended to kill her with a pillow, and I never said anything about a rope. Never mentioned the incident one bit. I'm also going to assert that they did not show any intent to steal a car. They did not show that was the underlying reason that Mrs. Mathewson went with me. They did not show that I intended to kidnap her. There's a lot of holes in their story. And I ask you to please consider that when evaluating whether or not you find the facts true. They also did not show my intent to take advantage of Ms. Mathewson in any sexual way. You've heard the way I've described it in my interview. You've heard the way she's described it. And I hope you can appreciate that. I also believe that you would find that they did not prove that I intended to steal a car, which is one of the later charges on this long list that they've put together.
Dragan, is there a study that shows how often jurors make up their minds based off closing arguments? Yes. I think the most important 2 parts of a trial are jury selection and when your client testifies, or when the 2 clients or 2 parties testify. Those are the most important parts. Outside of that, they say more jurors make up their minds during opening statements then they do closing arguments. But what they actually say is by the time opening statements are completed, which means jury selection, which we actually talk a lot about the case and what people think about the case and which way they would lean just naturally in their life. So with jury selection, opening statements, more jurors make up their mind there, then change their mind by the time we get to closing arguments. So that's why I say closing arguments really is to give tools to jurors that are on your side, basically as the defendant in this case, so they can go argue for you back there, not recapping all of the facts. But also in a criminal case, you do want to try to point out as much reasonable doubt as possible in your closing argument.
I believe you would find that it is a civil matter, and that when two people are married, they commonly use each other's vehicles, even if they are separate.
Objection, Judge. Improper argument.
Again, I'll instruct Mr. Summers to limit your argument to the facts and the law that are applicable to this case.
Gentlemen, I assert that utilizing cars while married is a civil matter. I also don't argue other issues. I ask you to just be favorable in understanding my position here. I ask you to please be cautious in understanding what burden of proof the state has to provide and how high that threshold is, that you cannot have doubts about these allegations. They are very serious.
Objection, Judge. Misstatement of the law.
I will instruct the jury that, again, what Mr. Summers says is not.
So what he was about to argue right there is, yes, I know this judge. I don't practice a ton in front of him because I'm very, very mostly doing injury cases in civil court. And what's interesting is he was going to go into the fact that these are very serious charges and he can go to prison for a long time. And that is something in our court system that you are not allowed to argue to the jury. You're not allowed to argue what the sentence is, how long the sentence is, because it could affect the sympathy that the that the jury may have for this criminal defendant. Like, wow, that long for this, man, maybe we should think twice about it. What else is interesting is my dad is trying a criminal case as we speak in another jurisdiction where they are actually allowed to tell the jury the potential sentence and the maximum sentence for the crimes, which is totally different. The rules are very different in how they pick their juries, what they can and can't argue. So it's very interesting, just kind of the different rules, different places. But here you are not allowed to argue that. And he was kind of going down that road. The prosecutor properly objected. So I stand corrected. That is another good reason to properly object.
The law, you will hear the definition of reasonable doubt when I instruct you.
Azam, I have one of your questions saved. I'm not sure if it's the one that you just referenced. No stupid questions. You know that. Meaning I don't consider questions stupid. But I did star one of your questions, so I'm going to ask it in a little bit, but it's in conjunction with another question that I have starred. So once this is over, I'm going to answer a couple more questions.
On that law.
And so, gentlemen, reasonable doubt, I believe, is everywhere. And I ask you to please remember that and to please focus on that element that has to be proven by the time that you make these decisions about my life, about the situation that you've been presented, about deciding whether or not to find me innocent or guilty. I ask you to please consider all of these factors and see that what I am trying to show you is that this was a very abnormal series of events, and it requires a lot more information for you to draw a conclusion that would say that I absolutely am guilty of these crimes. And so for all of these reasons, gentlemen, I thank you for your time. I thank you for giving me the opportunity to explain this to you and to share with you a better understanding of putting it together. I thank you for allowing me to paint a little bit better of a picture, and I do appreciate your time, and I value your opinion on this. And I do ask you to please find me innocent of the charges against me, and to consider what else may be available to you as you are instructed by the judge. Thank you. Thank you.
All right. So he argued a couple times there, find me innocent. If I'm a prosecutor, let that ride, because that's an even higher bar to me. find me innocent versus not guilty is a very different burden. They do not have to find him innocent. So that's just again, something that a non-lawyer would argue in a criminal case, but not great. Wait for rebuttal. She starts out with a video. Are you going to watch rebuttal? Tori asked both. I wasn't planning on it, but let's go ahead and watch. Let's watch just the beginning of rebuttal so we can see the video, because I did want to talk about it, because she comes out with this shot that I just think is perfect, a perfect way to start rebuttal. So let's go ahead and just watch the beginning of rebuttal. Whenever we ad lib, it's sure to go wrong. All right, let's see if this works. We're not going to watch the whole thing.
May it please the court, Mr. Summers, co-counsel, members of the jury.
Okay, Art and Landon, I need to give you guys some information, and I want you to make sure you understand this. I've spent a lot of time with Mom the last few hours, and the things that she's told you about me being good at manipulation, control, and lying is true. And tying her up.
That is Trevor Summers in a nutshell.
So that is an absolutely home run way to start, after he just got up and gave his, part of the story and his argument, basically him admitting that he's good at manipulation and he lies and things like that. To me, that is an absolutely great way to start it. Now, the weird thing to me, and what I would think, and you guys let me know if you disagree, why would he make that? How does that help him? And as I try to think through the reasons he would make something like that, that would obviously be beneficial to his wife, and he looks at his wife and says, anything else you want me to say? Things like that. But the only reason I could think that he may do that is if he really, and again, I think all of this kind of, if you think about it in this context, it kind of cuts in his favor, is he really believes, the only explanation I have for this is he really believes that his wife is going to get back with him if he does this. And if he admits this to the kids, then maybe she'll take him back and they'll have their life back. Maybe that's what he's thinking, but it's very weird. It's very strange. And that's why I'm saying, I don't think he had some master plan. I think he was all over the place. I think he was making bad decision after bad decision kind of as the night went on. But let's get to a couple questions here. So Azam asked, this may be a dumb question. If he represents himself, right, what happens if he wants to object to a question from the prosecutor during his testimony? That, in conjunction with Brianna's question, which was, had he testified, who would have asked him the question since he chose to represent himself? So if he were going to testify while he's representing himself, there's two things he could do. Either standby counsel could ask him questions. It didn't seem like the judge was going to allow that in this case. So the second way that he was going to do it in this case is he would take the witness stand, give what's called a narrative, meaning he just stands up and tells his story. Here's what happened. Here's what happened that day. Here's what happened in February when we got divorced. Here were our intimate encounters, things like that. He could just spill his guts, basically. And the prosecutor could object if he said anything that was inadmissible or said something somebody else said. But if the prosecutor objects, he would argue the objection and why he should be able to say it from the witness stand. It would be very wonky and weird, but he would take the witness stand. He would argue objections. He would say whatever he wanted to. He would answer the prosecutor's questions when she got up, and then when she sat down, he would have the opportunity to talk again as kind of the redirect of himself. He would be able to give another narrative. Very interesting, I know, but it's kind of cool to think about. AK-47 Mouth. Peter, do the optics of a lopsided gallery have any impact on the jurors? In a case like this, I would say no. In some civil cases, I think it may a little bit. They may think, why is there nobody here for them? Or why are there so many people here on that? So I think it could be interesting in certain cases, but Zachary's mama, why was he able to question his ex? How is that not re-victimizing the victim? You'd think that in 2022, the law would come up with a way to overcome this. So we talked about this a lot in the last video. Zachary's mom, I think was it Zachary's mom? Yeah, Zachary's mom. We talked about this a lot in the last video. The confrontation clause and the ability to face your accuser and cross-examine them and test their statement to see whether or not what they're saying is true and if it can pass muster and pass scrutiny. So to me, I think it is appropriate. I know how hard it is and how bad it sounds, but you have to think about for people that do get wrongfully accused, and where we live in a society where we try to keep things civil and try to do the right thing. And if somebody's going to go to prison for the rest of their life, we want to make absolutely sure it is correct. That's why it's such a high burden. It is difficult. It is difficult. Derby Mom, I just joined your channel. First time joining any channel. I think it was a good choice. Love your channel. Thanks for sharing your legal insight. Thank you so much. And if anybody's here from this trial here in my backyard, I am a lawyer here in Florida, in the Tampa Bay area where this trial is. If you haven't subscribed to the page, take a second, subscribe. Doesn't cost you anything to subscribe. If you want to join like this new member did, then you can take a second to join, but don't feel like you have to. The only thing you got to do is like and subscribe and comment and get in the conversation, and we'll have fun talking about things. Correct, Thomas. It's a good point. Constitutional right, but it doesn't mean the jury won't punish you for it. Absolutely correct. Especially if you want to take that on yourself and cross-examine your ex-wife and potential victim yourself. That is something the jury can hammer you for. And that's the point. That's why we put it in the hands of the jury. They can look at the optics and look at whatever they want and make their decision based on if they think he was just doing this to victimize her again, then he can get hammered for it. And the jury is gonna make the decision. All right, I'm trying to think. There was one other thing I thought I wanted to talk about here before we bounced. Oh, yes, verdict, of course. So, what do we think? What do we think the verdict's going to be? Well, let's talk about the charges. And I don't have all the definitions up to read to you, but attempted murder, kidnapping, sex assault, grand theft, and child endangerment. I'm pretty positive he's going to get convicted of child endangerment. So we'll start there. Second most confident one I think he's going to get convicted of is kidnapping. So those two, I'm pretty confident he's going to be convicted on. The other three are more difficult to me. The next one I think that's most likely would be the sex assault for him to get convicted of that. I think I would probably vote. I would probably vote guilty from what I've seen and heard, that she felt like she didn't have a choice. But it is kind of weird. I do think that the whole circumstances around how it happened when their divorce was going on in February, how they had sex right before it and right after it, and this one too, that is kind of weird. That's the only reason why I wouldn't say slam dunk on that. Grand theft. So this one is weird because, yes, he took her car, but she was with him the whole time. And if they believe that at times she wasn't tied up and could have gotten away and things like that, is it really grand theft? Did he intend to keep her car, or were they driving it together? To me, that one's even a little bit more difficult. I can see it going either way. The attempted murder, I realize everybody wants to hose this guy and convict him on everything across the board. It would be a pretty quick and easy not guilty for me if I was a juror for the attempted murder. Because he could have killed her. He had the opportunity to kill her and he didn't. The pillow, the rope, whatever you want to say, he could have killed her. Yes. Did he have horrible intent in his heart, potentially, obviously, to kidnap her if we convict him on sex assault and things like that. But I really think I would vote not guilty on attempted murder because I don't think they can prove the underlying elements, any intent to actually kill her. I do have, and I know chat's going to come at me, and I get it, and I respect everybody's opinion, and I'll listen to it. I'll read through some of them. What about the slit wrist and the pillow? Again, attempted murder, you have to want to kill somebody. And I don't think any of that stuff he did, he wanted to kill her personally. That's just me. If I was the juror on there and I read it. Okay, so a lot of you are saying, yeah, I would say not on all of them. Anne-Marie Mitchell said 3 out of 5. Rita said not on all. Sherry said me too. And Mr. RN said kidnapping and assault. Jamie said, I don't think he'll get attempted murder. Okay, so I thought that would be a little bit more of an unpopular opinion. But it seems like you guys are pretty in line there. Okay. All right. Well, that makes me feel better. The chat's not throwing all the heat at me on this late Friday. It's 5:00 somewhere Friday, and that somewhere is here. We'll be watching you from heaven, Kelly Jansen, him cutting his own neck. All that stuff is strange and weird. And again, talking about suicide potentially, or even murder-suicide. But again, I just don't think it kind of got far enough for attempted murder. Personally, that's cool. It looks like Jump for What and Zen Amen disagree. They think he will be convicted of attempted murder. Somebody said, objection, you're not a juror. That's facts. That's facts right there. Gap Year says entirely guilty. Elizabeth said he thinks he planned to kill them both. Acquit and no contact. They're both crazy, Andre said. I don't think he's going to get acquitted on all charges. I'm pretty confident of that. John O'Rourke, just want to state, this is obviously an extremely emotional case, but thanks for always explaining issues in a manner which both sides have rights to legally defend themselves. Hitting balls this weekend. Thanks, my guy. I just got done playing in our FJA Young Lawyer Board tournament, and your boy did bring home the prize and was the champion of the tournament, me and my partner, Danny. So we did take home the top prize, which was fun. It was a 2-man best ball net tournament. So we did win. Thank you, John, for asking. I love talking about golf victories. They're few and far between. So when I get excited on here. So thank you. So Karen, as crazy as it sounds, putting a pillow over somebody's head is not necessarily attempted murder. I know it sounds crazy. I'm just speaking legally. And I think if he gets convicted, he gets convicted, and the jury can think that he did attempted murder. I don't think it's like a slam dunk appeal. Like it's no way that any reasonable juror could convict him of this. I'm not saying that at all. I'm just saying that's the way I would vote because I don't think they proved the elements needed for attempted murder. Azam, thank you for the super sticker. Thank you. Thank you, John. Thank you, Kelly. All right. This was fun. I mean, this was as last minute as could be because I didn't even know when I was going to get home from the golf tournament. Got home, popped the live on. I did listen in the car ride and stuff to the States opening or their first and second close. I wonder if he totally understood that they were going to be able to come back for another 40 minutes. They split theirs almost in half, I think 40 minutes each, and he had 30 minutes in between. So that was interesting just kind of see. And we'll see. We'll keep track of the verdict. I'll probably do a short or maybe a late night live. My wife and kids are out of town. Maybe we'll either do a late night live or sometime tomorrow and talk about the verdict, especially if it's interesting. If it is, Sherry said, I missed your super chat. I will give it a second and scroll up here. Oh, I missed Joe's too. I'm on my own because I told all you guys Rachel was out of town this weekend. So I'm doing everything I can to get as many of them as I can. No guarantees I will get all of the super chats, but I do my best. Sherry, I'm scrolling up looking for it. Why don't you post in the chat again so I can get your question answered here because I am going to take off in about 2 minutes. But happy to answer your question, especially if I miss a super chat. And And thank you, Leah, for the super sticker. But yeah, I do sometimes stream on the weekends. I am on my own this weekend, like I said. So I will try to stream for sure. I am also going to record part, what are we on, 6 or 7 for Amber Heard's 2016 deposition. I'm going to record that this weekend, and we will post that next week as well. So get excited for that. Trying to give Sherry a chance to post that question again. Thank you so much, Mr. RN. John, yeah, I don't do well without him. My ladies and my little guy. Thank you, John. Thank you, Aaron. Mom's in. I think the jury will come back tonight. So they stayed really late one night, like 7, 8 o'clock at night. They stayed one night. So I think he'll let them stay late. The jury's not going to want to come back on Monday, I wouldn't think. But you don't want to rush a serious case like this. Wait, verdict is in? All right, they said verdict is in. So let's see here. Verdict is in. All right, so we might as well here try to find it. So I see nothing on the verdict being in. Yeah, no, it's not in. I just looked. And Sherry, okay, so Sherry did post it. She says, see above. Okay. Why was DNA so important if she admitted she willingly had relations? Yeah. And he even argued like, oh, it wasn't my DNA, but he also admitted that they had relations. So I think if anything, it creates reasonable doubt, which I don't think it does. But I think if anything, it creates reasonable doubt that why wasn't his DNA there? You know, I do think that the DNA was not as important to me as it seemed like it was in the trial. But I mean, you guys let me know. Did you think the DNA was important if you were a juror on this case? I did not find it to be incredibly important in this case like it is in some other cases. Thank you so much, Jamie. I thought it was fun too. Yeah, everybody's saying it is not in. So here's what I'll say. Either tonight or tomorrow, maybe I'll do a short, maybe I'll jump on and do a live. I assume would you guys come if I did a live? Would you come join me for a verdict discussion if I did a live? I'd have to set it all up and try to figure out how, and it would probably be last minute. So hit that subscribe button, hit the bell, hit the like, hit the comment. So yeah, go ahead. Oh, you're right. He had to take a shower. That's interesting. So maybe that's why they could combine all that together. That's a good point, Kathy, Viking Queen. But I will try to do a live later. I've got 2 events with the Young Lawyers Board tonight, and then 1 tomorrow during the morning and early afternoon. But at some point, I will do a video or a live. Yeah, buy the merch. Tina said, "Go ahead, buy the merch." Lawyer, merch. And I think the verdict will be in before the weekend, and I hope it is. But okay, cool. We'll talk more. We'll talk more about the verdict. Thank you, everybody, for joining us. Hit that like button on the way out if you haven't already, and tell your friends to subscribe too so they can come join the conversation. Appreciate you all as always. Have a good weekend, everybody.